In this section, we're going to start our coverage of negotiable instruments. And negotiable instruments are basically instruments that allow us to transact business without carrying around cash. So checks, credit cards, drafts, notes, these are a substitute for money, and they're used to obtain credit. With the rapid development of cyber commerce, of course, we know about e-commerce and online payments, Apple Pay, credit cards, all of those things. Even though these are all new things, they are all covered under the law of negotiable instruments. So a negotiable instrument is a written document signed by the maker or drawer that contains an unconditional promise to pay or an order to pay a fixed amount of money, either on demand or at a definite time in the future, to the bearer, which means the person who holds it, or to order, which means to the person to whom it was ordered to be paid. There are different kinds of instruments. There's promise instruments and order instruments. A note is a type of promise instrument. A note contains a written promise by one party to pay money to the order of another. And the party who's paying is the maker. The party who receives payment is the payee. These are often called promissory notes. There are different kinds. There's a demand note, which is payable whenever the payee demands payment, so at any time. There's an installment note, and that's payable over time. The principal, so the amount we owe, plus interest on the unpaid balance is going to be payable in installments at specified times. And then there's a certificate of deposit. This is made with a bank, and it's an instrument containing an acknowledgement that the bank has received a sum of money and a promise by the bank to repay that sum of money, with interest usually. Here's an example of a demand note. We can see the maker here is Victor Powell, all right, and we can see that the payee is Cambridge Trust Company, and we see the amount. We see the interest rate, 6%, and we can see that this is a demand note because it says on demand. So that means whenever Cambridge Trust Company demands payment, they will receive $2,400 plus 6% interest. There's also order instruments, and one is a draft, which is an instrument in which one party writes an instrument ordering a second party to pay money to a third party. So you can already see the difference between notes and drafts are the number of parties. With a note, there's just two parties. We have the maker and we have the payee. But with a draft, we have three parties. We have the payee, we have the maker, and then we have the person who's ordered to make the payment. So that a check is a type of draft. A draft isn't always a check, but a check is always a draft. A sight draft is payable as soon as it's presented to the drawee for payment. All right, so here this is kind of blurry, but here we have a sight draft, and we have the payee is First National Trust of Springfield, so they're the ones getting paid. The drawee is Ciro Distributors, so that's the person making the payment, and the drawer, the person making the draft, is John Romero. Okay, and then a time draft is not payable until the lapse of a particular time period stated on the draft. And this one you can see it's in or within 60 days. You can also see that this draft has been accepted because it's written on the face of the instrument. That's the only way to accept a draft, is to write your acceptance on the face of the instrument. A check, like I said, is a type of draft. It's a draft drawn on a bank and payable on demand, and it's the most common form of a draft. So this is what we think of. We have money in a bank, and when we write a check, we are the maker, and we order the bank, who is the drawer, to pay the payee. Okay, so again, we're the drawee when we order the drawer, which is the bank, to pay the payee. A certified check is a different kind of check that's guaranteed by the bank, and they're guaranteeing that sufficient funds will be withheld from the drawer's account to pay the amount stated on the check. So if you've ever purchased something like a larger thing, a larger item, they probably required proof of funds, essentially, by a certified check. And so a certified check basically says by the bank, yes, this person's account has the money in it, and we are going to guarantee that we will pay this check. It will not bounce. A bank draft is a check drawn by one bank on another bank in which it has funds on deposit in favor of a third person. And then a cashier's check is a check drawn by a bank upon itself. There are also traveler's checks, which aren't really used that much anymore, but in a traveler's check, the issuing financial institution is both the drawer and the drawee, and the purchaser signs the check in the presence of the issuer when they're purchased, and then when they want to use them, they essentially sign them again. They write their name, they write the name of the payee, and then they countersign the check in the payee's presence. And finally, there's a money order, which is a type of draft that may be purchased as a substitute for a check. And instead of being drawn on an individual's account, it's drawn actually on the funds of the organization. In a money order, a lot of times a person will go into a bank or someone who issues these money orders and give this organization cash. This organization will create a draft then that allows that person to pay by a check rather than carrying around large sums of cash. All right, so these are the parties to different negotiable instruments that we have talked about. And this chart shows it a little better. So the first one we talked about is a note. And in a note, remember, there were essentially two parties, right? There's a maker who promises to pay funds to the payee. And those are really the only two parties to the check. We have on here, as you can see, the endorser. An endorser is a person who endorses or signs a negotiable instrument. In most cases, you just do that by signing your name on the back of the check. And so we know this. If we have a check, we usually endorse it before we cash it at the bank. You can also endorse it to someone else. So rather than just signing your name, you can say, pay to the order of John Smith. And then John Smith can present that note to the maker, and John Smith would have to be paid on that. And then John Smith would sign it to show acceptance and receive payment. Next, we have a draft, and remember the difference between a draft and a note was that there's one more party to the draft. We have the drawee who orders the drawer to make payment to a payee. So we normally think of a bank, so an individual who has an account at a bank is the drawee, the bank is the drawer, and then the payee is the person that the drawee wants to pay. And again, you endorse those to receive payment, and you can also endorse them to transfer them to another party who can receive payment. And parties to a check, you can see this is exactly the same. Checks are drafts, so it's the same parties as we discussed in a draft. Negotiable instruments require the following. They have to be in writing. They have to be signed by the maker or the drawer. They have to contain an unconditional promise or order to pay. They have to be made out for a fixed amount of money. They have to be payable either on demand or at a definite time. And then except for checks, they have to be payable to the order or to the bearer. So a writing can include any type of writing that we want to evidence a promise to pay. So printing, typewriting, pen or pencil, any other tangible form of writing. And a negotiable instrument, like we said, must be payable in a fixed amount or a certain sum of money. So it must be clearly known what the recipient of this negotiable instrument is going to receive. And then must be payable on demand or at a definite time. So on demand means I can receive payment whenever I want. A definite time says I know when I can receive payment. So in 60 days, after April 1st, something like that. So this makes it possible to determine when the debtor or promisor can be compelled to pay. And then it has to be either payable to order or payable to bearer. Payable to order means that it's payable to the order of any person with reasonable certainty. So if I have a check and I endorse it on the back, payable to order of John Smith. John Smith can cash the check. The second one, payable to bearer, means it is payable just to the person who has the check. So it's payable to the bearer or the order of bearer, a specified person or bearer, or cash or order of cash, or any other indication that does not designate a specific payee. If I have a check and I sign the check just with my name, so it's payable to me, Ashley Schick, and on the back I sign Ashley Schick, I have now endorsed that check to bearer, and that means anyone who has that check can cash it. So on our own personal checks, we probably shouldn't do that, right? We probably should make a specific endorsement. We can endorse it to cash. We can endorse it to somebody else. You can write for deposit only, Ashley Schick, right? So we don't really, if we have a check, we probably don't want to make it bearer paper. We don't want it to be payable to whoever holds the check in case we lose it. And of course, the negotiable instrument has to be signed by the maker or drawer. To be negotiable, it must be signed, and any writing, mark, or symbol that is accepted as a signature as long as it's the writer's intent to be a signature. So it could be an X, it could be a scribble, it could be anything. The instrument has to contain an unconditional promise or order to pay. So it must contain no conditions that might in any way affect its payment. A statement that's going to require something to be done or some event to take place prior to payment would make it a contract, not negotiable paper. And I can transfer negotiable instruments. That's called assigning them. And it's the transfer of a contract right from one person to another. And with negotiable instruments, I can transfer them simply by negotiation. So negotiation is the transfer of an instrument in such form that the transferee becomes a holder. And a holder is a person in possession of an instrument issued or endorsed to that person's order to bearer, or in blank. So when an instrument's transferred by negotiation, the person receiving the instrument is provided with more protection than was available to the person from whom it was received. The person receiving it is able to recover money on the instrument even when the person from whom the instrument was received could not have done so. So they even get better standing. All right, so an instrument, like we have said, is endorsed when the holder signs it and indicates the intent to transfer ownership to someone else. Endorsements can be written, typewritten, or stamped. You can also have a blank endorsement, and we talked about that with a check. It's just the signature alone on a written instrument. So no endorsee is named. This is a very broad endorsement, and like we mentioned, if you have a check and you endorse it that way, if you lose it, whoever finds it can cash it, and they have the legal right to do so. You can also make special and restrictive endorsements to protect yourself. A special endorsement is made by writing the words "pay to the order of," or "pay to" followed by the name of the person to whom it is to be transferred and the signature of the endorser. If I have a check made out to me, Ashley Schick, and I want to transfer that to someone else, I can, on the back of that check, write "pay to the order of John Smith," and I sign my name, Ashley Schick. And this gives John Smith the right to accept that negotiable instrument and collect on it. Restrictive endorsements are going to limit the rights of the endorsee in some manner to protect the rights of the endorser. There are also conditional and qualified endorsements. A conditional endorsement purports to make the rights of the endorsee subject to the happening of a certain event or condition. That is a type of a restrictive endorsement. A qualified endorsement is one in which words have been added to the signature that limit the liability of the endorser. Endorsers also provide some warranties. They are entitled to enforce the instrument. The endorser warrants that all signatures are authentic and authorized. They warrant that the instrument has not been altered, that the instrument is not subject to a defense of any party that can be asserted against the endorser, and that the endorser has no knowledge of the bankruptcy of the maker, acceptor, or drawer. And every endorser does agree to pay any subsequent holder the face amount of the instrument if it was dishonored, so not paid by the maker or drawee. If I have a check and I have endorsed it to someone else, that person presents it for payment, that check bounces because I have no money in my account. That check is dishonored. I have a contract now. I have an obligation to pay any subsequent holder the face amount of that instrument. In the case of an unauthorized signature or endorsement, it's one made without actual, implied, or apparent authority. It's conversion, the wrongful exercise of dominion and control over another's personal property. All right, but there is an exception there. Someone who impersonates another. When an instrument's issued to an imposter on the false belief that the imposter is the payee, the endorsement by any person in the name of the payee is treated as an effective endorsement, even though it's really not. When an agent or employee of the maker or drawer pads the payroll by supplying the employer with fictitious names, an endorsement by any person in the name of each fictitious payee is effective. So we're not going to have a claim against the bank, for example, for paying on those negotiable instruments. When the maker or drawer of an instrument intends the payee to have no interest in the instrument or the payee is a fictitious person, an endorsement by any person in the name of the payee is effective. So again, if we are trying to fool the bank and we draw an interest to a fictitious person, an endorsement by the person in that name of the fictitious person is effective and we'll have no claim against the bank. Now we'll still have a claim against the fictitious person, but the bank is not going to be liable on that.